Thank you so much for coming. It is so great to see such a packed room. Obviously, that helps that it's a smaller room, but it's great to see a packed room. And it's really great to welcome you as the director of CIPL to our spring conference for the first time, I think, at least in many years, on a data protection topic. So on the information law side of things, rather than intellectual property, which is also an area which we've covered for many years. We have a very, very wide agenda, the changing nature of data protection in the UK, obviously, but also in the EU and perhaps even further afield. I'm so grateful to so many speakers for agreeing to come and talk on, what is a difficult subject, actually, but, from the worlds of academia, obviously, but also data protection authorities, civil society, and business. And I think that, we've often heard the GDPR is a sort of gold standard, and I'm sure that term will come up today. And I remember Giovanni Buttarelli, European Data Protection Supervisor, very much sort of championing the GDPR. Nevertheless, they are, and I think, we should all pay tribute to what the GDPR has sought to achieve and what it does achieve. Nevertheless, they are two powerful lines of criticism about GDPR, which I think we should try and explore today. I obviously don't want to sort of preempt other perspectives. One is that the GDPR is sort of an overly prescriptive, too broad, too one-size-fits-all, which is ill-suited to the very varied risks, nature as well as scale of data processing today. And the other is that, despite it trying to, set a standard, poor implementation has often been the reality of GDPR, and that's related to sporadic, or one might say, ineffective enforcement. And the relationship between those two concerns is actually quite complex. I mean, you can both run an argument that, if only we cared about this instrument, we would have good enforcement, we could have good implementation. But we could also run an argument that it's because of some of the pathologies in the structure and nature of GDPR that it becomes something which is unmanageable in a way that results in poor implementation and poor enforcement. Now, obviously, the issue of the over-prescriptive nature of GDPR has particular resonance in this jurisdiction post-Brexit. We have, and why the title of the conference is Data Protection Reform, is we obviously have a live data protection and digital information bill before Parliament. Now, whether that really addresses the sort of key structural issues which I'm talking about, I think will be another thing which we'll perhaps want to focus on today. On the side of sporadic and ineffective or potentially ineffective enforcement, we might return to the EU with its problems over the one-stop shop and its proposals for a regulation on that area and the issue of sort of procedural requirements in general. But UK experience does show that the one-stop shop must be far from the only factor in relation to this, because we hear very, very similar concerns in this jurisdiction about implementation and enforcement. In any case, I do not want to take up loads of time giving you my perspective. We have a fantastic lineup of speakers to provide a much broader range of perspectives. And therefore, without further ado, I'm going to hand over to the Deputy Director of CIPL, Dr. Jennifer Cobbe, who will kick us off with a look at the UK substance and UK reform.
Hi everybody, good morning. Thank you very much, David. We have a panel coming up which has three excellent speakers. We have Michael Veale from the Faculty of Laws at the University College London. We have Gavin Freeguard, who's a Policy Associate at Connected by Data. And we have Vivienne Artz, who's a Data Strategy and Privacy Policy Advisor to the Centre for Information Policy Leadership. We will probably just do presentations and some questions and a bit of discussion in the order of people as they're on the programme. So Michael is up first. If you have your You don't have slides. Okay, even better. I will leave it to you. So you have 15 minutes, I think, and then we'll move on. Thank you.
Cool. Thanks, everyone. Daunting to start off the day on a big and timely topic. So I've been asked to talk a bit about the UK data protection landscape, and of course that's the UK nested within its past and present context. And like all technology and information law, we end up talking about proposals as if they're real, but also in the middle of a process that we don't even know will happen yet. We should be kind of careful when we talk about proposed legislation. So I suppose to start with what's working and what's not with UK data protection. Now that's a really big issue, a really big challenge, and it's a big challenge because UK data protection is so wide in scope, like European data protection law in general, ranging from individuals to companies to public sector organizations. But I think there are some things that are working well in the UK. We have some pretty thoughtful case law around some of the difficult definitions in data protection, maybe not as much as we'd like. But we haven't, for example, fallen into some traps that the Dutch had fallen into before with their case law around access rights, where there were big discussions around what they were for and were they purpose blind and so on. And it just seemed to be like lower courts didn't really understand the much broader picture of the intention of the regime. Whereas I'd found that at least in England and Wales, we've got judgments from, say, the Court of Appeal, which are pretty clear on this and don't fall into a trap of thinking the data protection is super narrow or only restricted to privacy interests in the conceptual way it's set up. Because we saw in the Netherlands, these had to be undone later on. So I think we've got some good senior judicial analysis of this. And we've got some similarly good analysis of some of the emerging challenges around the scope of personal data. We've had some rocky times in the past with UK jurisprudence on that. But for example, the Bridges case, which is one of the most important bits of data protection case law recently in the UK around facial recognition and the police, had a really interesting observation that you could have data protection could be triggered as an interest, even though the person might not be directly identifiable themselves at that moment, just because the purpose of the system was identification. And it kind of moved away from this proceduralist view of let's have a look about how we link data up to a view that's much more about the purpose of a system. And that's important because we see companies like Apple moving a lot of data to their devices in order to process quite invasive things about individuals, yet to do so risks falling out of data protection if there's bad interpretation of the law. I don't think it's a necessary risk, a necessary outcome rather, but I think it's a risk. I think we've also got some good things. We have not got a focus on highly procedural or legalistic enforcement. We don't see a lot of enforcement cases around not having records or not having an appropriate DPO at a certain point in time. The ICO, for example, when it does do enforcement, seems to be more comfortable than some other DPAs at enforcing on the basis of data protection principles, which I think is a key area to go by, because if we stick on the principles, we can be a bit more flexible and we can analyze things that seem to be wrong in digital society. I'm not saying that enforcement is perfect there, but I think the confidence in doing that contrasts with particularly some civil law jurisdictions where they kind of feel like you have to find the nitty-gritty in order to catch a controller, and that just adds, I think, to the bureaucratic perception of data protection and detracts from its real protection and what it should be focusing on. We also find in the UK that the ICO is one of the highest capacity regulators for analysing problems. It's missed a lot in the European Data Protection Board by the other high capacity regulators. It has definitely produced interesting analysis. It has been the rapporteur on interesting EDPB guidance before, and it can continue to do that in the UK. And is setting out interesting documents at the forefront of emerging technologies. Now, I don't think that's linked up as strongly as it can be to enforcement and the other parts of the ICO, but I want to focus on the good things for a moment. And it's been, the ICO has been willing to challenge in some complex areas. Political parties in the past have been subject to the ICO, and that may triggered some of the DPDI bill. Some skeptics or cynics might say. And indeed have I think, backed up quite favorably, to my understanding, some of the work, for example, by the Open Rights Group on the immigration exemption and so on, and have been bold in supporting that and has steered that through. So we have seen some challenges on some difficult areas. So that's maybe what's working in UK data protection, I think, institutionally. What about the DPDI bill? I've gone straight to the acronym, but hopefully you all know what that is, or at least have heard of it. Data Protection Digital Information Bill. I know some people here are not based in the UK, but the context being it's an act that amends both the UK GDPR, which is the retained bit of EU law when we retained regulations and they moved into domestic law. The act amends that. It also amends the UK Data Protection Act, which does things like sets out the institutional scene for the data protection regime, and also sets out law enforcement processing and under the Law Enforcement Directive, and intelligence services processing under Convention 108. And it amends some other things as well, like EIDAS and already the Online Safety Act 2023, which some might say they've barely got to the page before it gets amended. So what's working with that? Well, it's a weird bill. It's quite a weird bill. It's a bit of a mishmash of a lot of things. I mean, one thing that's working is that it's not the Data A New Direction paper, which was a quite mad set of suggestions from DCMS, or the department formerly known as DCMS, soon to be known as X, I think. DCMS presented this which had some reasonable areas and some areas that were just kind of wild and would dismantle like a lot of the rights that are in data protection. So it's not that. Clearly, both industry, civil society, and other people came up and said some of those things are really quite dangerous to do and endanger not just adequacy, but just the integrity of your entire regime. But there are good things in the DPDI bill. I'm pretty supportive of most of the parts around cookies and terminal devices. The main reason is these are predominantly the kind of reforms that I think both data protection authorities have been trying to make on their own without changes to the law, and would seem sensible if you define them narrowly. Broadly, these exemptions relate to carving out the e-privacy directive, which is a very small piece of legislation, which just says in a few lines that if you are putting or storing or accessing data on information on a terminal device, so like a browser or a phone or something like this, that is not strictly necessary for using the service that someone has requested, for providing the service someone has requested, then you need to provide informed consent. Now, what is it to be necessary for this service is a big question, but I think there are many parts where data protection authorities have said, well, we put cookies so that, say, your accessibility needs are remembered from one page to another, or some things to protect DDoS attacks, or some things just to measure page counts without really tracking you across either the site or across sites. And they're pretty conservative proposals inside the DPDI bill for things that most data protection authorities that have tried to think about this already say, and the French particularly say, we consider these to be strictly necessary for the service. There is a more dangerous part, which in the trend of recent UK law just says, and the Secretary of State can decide anything else in the future that they feel like, and that should definitely go. But the actual substantive part is there. And there's also an interesting hook on saying maybe we'll work out some do not track signals in the future and some binding objection requests, which is a nice ground to play with. Again, maybe a bit too much executive power for my liking there, but at the same time, it's a good direction. So broadly, these are the reforms that I think many would have liked to have seen in the EU, but can't do because of data retention. And you can't open up the e-privacy directive or regulation in the EU because of the French not wanting to have lost further their powers over telecoms companies and similar to request them to retain data in their ongoing fights with the Court of Justice. So that's sort of the background there. There's also some interesting parts about nuisance calling. I think that's been high on the political agenda because people don't like it. But there are parts about political calling and political robocalling and similar, which perhaps could be reined in again. So there's good parts of the DPDI bill, and there's a lot about in data intermediaries, interfaces, and identity and so on that I'm less familiar with, but probably people have found some good things there because there are areas that seem quite boring to me. And if they seem quite boring, they're probably doing tiny little fixes that people found to be fairly handy and if parts of the law, as well as maybe sneaking some stuff in that I can't call out or pick out so easily. So I'd love to hear more about those from participants if they are aware of the more arcane parts of the bill there. So what's not working with the DPDI bill? Well, I think one challenge that not just the ICO has, but regulators across Europe, is that they are dealing with a complex multi-actor world and an uncertain body of law, and enforcing it asks several questions, such as what does this law say? What does this law mean? Who do we target with this law in supply chains or algorithmic networks? Who is responsible? Who should be responsible? And when we do that, I think we have to see these regulators as tied down with a variety of complexities, technical, organizational, institutional. And this, the DPDI bill ties the ICO down with further duties to consider as far as the Commissioner considers appropriate to the case, things like innovation or competition, which are certainly things that need to be, I think, considered in digital policy more generally. But I think putting them on every individual regulator to consider within their own remit is a different approach than having fora for discussion and thinking about coordinated action between them. And sometimes that, I think, can distract an organization and just add further complexity when there is already a difficulty to take final action to deal with ultimately what is a political economy question around the way that the digital environment is set up and interventions in there might need to change. There are these changes to the definition of identifiable individual inside the law, and I think others may talk about that too. But my concern for that is particularly how it interacts with the nice strand of case law emerging from Bridges, which just says there's actually a sort of singling out side of things that you have to consider. You can't say that a smart billboard that is profiling people as they go past and delivering adverts to someone as they go past is not doing something in the world just because the smart billboard company can't pull out the data and tie it to a single person, because these are data processing operations. When we look back to the point of data protection from the 70s onwards, it's really to counterbalance digital power and information asymmetries and power caused by those. And if we just say, well, we're just hanging it all on confidentiality, but instead someone can make a web browser that targets you hugely and micro-targets you hugely, but if that company can say, well, we can't identify you from this information, then they can say that's not a data protection issue. Now, that's not the only way to interpret the changes in the DPDI bill, which do define narrowly. The problem is, it's a bit weird because the court in Bridges stepped back from that definition a bit, also looked at the recitals and the context, and gave a different strand for identification. But then this bill particularly focuses down on this identifiability strand. And whether that focus would make a court feel like it's gone in the wrong direction and it needed to come back to the Breyer test and these kind of approaches as the main way for scope, or it felt bold enough to develop on this, is hard to say. But one thing we do know is a missed opportunity to codify some of that direction in Bridges, have a discussion about that, and think about when you are practically singled out, differentiated from other people as part of a digital infrastructure, data protection should also be applying in those cases. So it's a missed opportunity there as well, particularly when we look at the movements of companies like Apple and Google, which are moving really heavily in that space to profile individuals on devices. But also, I was on the train over this morning from Stansted, because I'm based in the Netherlands at the moment, and the train inspector came over with a ticket, and he had a camera on his chest and a microphone. So I said, oh, can I ask a question? Is that recording all the time? He said, oh, no, it doesn't actually remember. It records every minute, and then I press the button, and if I press the button, it retains the minute, and then we'll keep going. And that's not a terrible design. Like, it's a pretty sensible design, I think, for those situations. If you're going to design something, like, it's better than it recording the entire time, or recording for like an hour or two. But at the same time, I wouldn't be comfortable if someone said, that means that this recording doesn't need notification, or you don't need to tell people this recording is going on, because in practice, they have been recording what's just happened. Just takes a button to press that, and just retroactively saying that was when the purpose and the legal basis was established isn't really satisfying for me. So I just think that's, and I haven't done an extensive legal analysis of that case, but I think it's just an example of, because it only happened about an hour and a half ago, but it's an example of just seeing this kind of I'm forgetting technology, but I'm still acting in the world in real life, even between here and the airport. So what is to be, sorry, one other part before I say what is to be done. The research purposes section of the DPDI bill is also potentially problematic when we look at the role of foundation models and large machine learning systems. This is because, as people like Jennifer Cobbe have written about extensively, AI as a service is a pipeline, and models move around, and models are traded between different partners, and there are huge linkages where they pass from one actor to the other, and ostensibly are supposed to secure legal basis as they do so, or some grounding in the law. But there's a risk that, the same with copyright, this occurs as well, that you say, hey, we benefit from an exemption at this point, but we have been sufficiently transformative of the information, so we've scraped the internet, we've trained a big model on everyone, whether it's personal data or copyrighted information, which required processing that model or utilizing that information. We have now transformed it into something else, which we claim, might not be right, falls outside of the law, that we can then make mobile to another actor who doesn't have that responsibility. So you get a laundering system that can occur through the passing on the initial benefit of an exemption following the passing of this downstream to other actors, which we just have to be careful about. And so it takes me to the last point here, which is about what is missing that we would need and what is to be done. Well, we have to zoom out of it, because if we take too much of an atomistic or granular view on data protection, we are just going to see one controller or actor at a time. If we do so, we're going to get strange outcomes. For example, there are restrictions on the right of access in the DPDI bill. They say things like you should consider the controller's resources when you do that. What about the joint controllers? We've seen joint controllership in a lot of places. Just because there's a small company that's actually orchestrated by a very, very big one, are you meant to consider the fact that Google is running the ad tech system as a whole, even though this tiny ad tech company is there without many resources to answer your request? Do you consider just their resources or the whole joint controllership arrangement? Because if you don't consider the whole arrangement, there's a huge opportunity for arbitrage and structuring a supply chain so that you fall outside the law. And here as well, with machine learning models and so on, this structuring to avoid the law is going to become a really big problem, I think. So we have to target it by zooming out, take the regulator out and say, we are confident, we have the capacities, we have the powers to look at the entire political economy of this and to analyze it for what it is. And that's taking inspiration from things like competition law, which don't say, I'm sorry, we can only look at this single legal actor because that's our powers. It says, no, well, the world is the world. Like, we can draw on a lot of things to try and make a narrative story of what is going on. And they obviously have a lot of examples to do that from. But the problem we've had is that a lack of enforcement has led to no real clarity on those powers existing. So my final point then is how we get that clarity to get those powers to come together and that confidence to zoom out. Well, one part is that it's quite hard to generate the data protection case law on these complex areas. It's a very bad idea to send an individual or even an NGO in a direct legal fight against a tech giant. In the English system, it will likely bankrupt them. It's very post office style. They will pour in all the legal methods they can in order to try and stop something happening that they don't want. Now, that's just an average access to justice question, but we don't usually ask individuals to go to the High Court for consumer law or something like this and put them in this position, nor for competition law if they feel like they're engaging in a market which is giving them issues and problems. So instead, we have regulators that can do that, and those challenges exist. For the ICO, they also need help creating this strand of law, and I think a big challenge is that their decisions are quite difficult to also challenge by complainants. Now, this is a bit of a dangerous area to go down, because a lot of what the ICO gets as complaints are totally mad. And so if you allowed everybody to issue a substantive challenge at the tribunal, you would also see, say, interpersonal disputes quickly become subject to regulators, tribunals, and the like. So instead, I think we might need to think of systems where there is a certain bar, but there is access to the tribunal, which allows quite easy clarification and probing of certain issues and challenges on a substantive basis. And to think about that, and that the ICO also shouldn't be too resistant to this, because it gives them a flow of certainty where they can also be more comfortable in relying on their ambitious readings and powers of this as well. And it's, of course, difficult for institutions to change, especially if, like many regulators, they've got an enforcement department full of ex-coppers. But that's a certain kind of breach that you're used to. Knock on the door, and find out what's going on. Oi, what a data breach going on here then? Let's find out what's happening. I can see it leaking down the bottom. No, that's the old type of data protection. You don't knock on the door and say, what have I got here then? Oh, it's 15 years, 20 years of non-enforcement against a system that is entirely built up, bottified, like a terrible political economy of data extraction. So I'm going to close this door. I'm going to go over to the data breach over here. They need confidence to deal with that, and I think we should be helping them with it. And I hope that's what the DPDI bill can do. Thanks a lot.
Thank you very much, Michael. That was a pretty enjoyable rundown of some of the good things and some more of the bad things about the DPTI bill. Our next speaker is Gavin Freeguard, who is from, I've completely forgotten, he's a policy associate at Connected by Data. You have slides, which I will get up on the screen now. And he is going to talk about, again, the changing landscape, particularly around the DPTI bill, from his perspective. Thank you very much.
Good morning, everyone. As you've heard, I'm Gavin Freeguard. I'm a policy associate Connected by Data, so very much bringing the civil society perspective this morning. You'll also see me pop up elsewhere, such as the Institute for Government and the Open Data Institute. And yes, talking about data protection landscape, Michael's given me a very good intro to some of that already, with a particular focus on the data protection bill, or as one of my colleagues remarked, given how many false starts we've had and how long it's likely to drag on, perhaps we should be calling it the data protraction bill instead. For those of you that don't know Connected by Data, we're a relatively new campaign to try and get communities and as well as individuals to have a powerful say on data and AI to help create an equitable and sustainable world. We're quite small and we believe that data and tech, they are political, collective, democratic issues. They're not just for technical experts. It shouldn't just be about individuals, it is about the collective, it is about the future of our democratic rights as well. The sorts of things that we're trying to do, first of all, change the narrative around some of these discussions rather than talking in abstract ways about data, trying to understand what this actually looks like in work, in health, in education, on the ground for people and communities, supporting those people with practice about how you can actually make these things better, as well as changes to public policies. We work openly and collaboratively and try to empower others to have impact as well. What does that look like around the Data Protection and Digital Information Bill? Well, for a year and a half or so, we've been convening a fortnightly meeting of civil society organisations who are interested in the bill to help coordinate what we're doing around amendments and how we're approaching campaigns and so on. We also produce a fortnightly data policy digest to try to keep up to date with everything that's happening. Although given that most of those are now stretching to 4,000 words, I think dissertation would be a better word than digest. So I'm also going to cover what's working, what isn't with data protection at the moment, what DIPDIB, and I will use that acronym because otherwise it's going to take up most of my time to say it out in full, what that will actually do and what should be done to it or instead. So what's working and what isn't at the moment? Well, I think one thing that we think probably isn't working brilliantly at the moment with data protection law is that everything's sort of pushed down onto the individual when it comes to decisions about data. And that sort of stems from the sort of consent model. And actually, we're not necessarily that good at making individualised decisions about data. There are constraints on our time, on our knowledge, and actually the way that the data economy has developed means that we are connected by data. Other people's data has an impact on decisions made about us. It's also very difficult for us as individuals to be able to take into account the collective impacts that data has, for instance, on our democracy, on our economy, on our environment. So we need an element of collective say in there as well. So again, we're not very good at making those decisions at an individual level. This is from an academic paper, which just gives you a sense that somebody trying to make individual choices, there's actually quite a lot to think about. They don't have the time to do it. They're being nudged by the choice architecture in particular directions. It's often said that people don't care about privacy so much anymore. Well, actually, they do. It's just they don't really have that much of a choice in a lot of the services that they sign up to. So that sort of individual consent model is not the only thing that we need. Big data is relational as well. Again, the way that the data economy has developed. This is a sort of paper from Vivienne, which talks about the fact that perhaps a few decades ago, the model was organisation makes decisions about you based on your data. Actually now, the way that data is used is in aggregate, fueling algorithms with data from lots of different places to make decisions about you. It's not just about your data, it's about my data, it's about everyone's data as well. So we should probably care about that sort of relational and collective too. And data also has those collective impacts. You think about Cambridge Analytica and the impact that had on faith in democracy, or you think about the power of big tech companies who are able to dominate markets. You think about the environmental costs of data centers, especially when we're talking about AI, compute, cooling facilities, and so on and so forth, which again are quite difficult to think about at an individual level. And something that we talk about quite a bit is the need to recognize decision subjects as well as data subjects. So if you're a data subject, decisions are being made about you and it's using your personal data. You have certain rights around that. But you might be a decision subject. It's not actually your personal data that's being involved in the decision, but it is having an impact on you. Now, we asked AWO, the law firm, to look into a few examples of that. So, for instance, communities that might find themselves over-policed because of historic crime data. Or you've also got maybe train companies introducing surge pricing based on historic travel patterns, social media companies making moderation decisions about foreign language or LGBTQ plus content. All of those things, you might be a decision subject rather than a data subject. It's having an impact on your life. But AWA found that actually the rights available to you are much less, much fewer than if you were a data subject. So we also need to recognise decisions can impact people even if their personal data is not or is barely involved. So for all of those reasons, we think it'd be quite useful to have some sort of data protection reform. Also, I think something that will come up quite a lot today, that the pace with which everything is moving, obviously the explosion of interest in AI recently, we do need to look at the regime. And as Jim Knight, leading for Labour in the House of Lords on one of the most recent data protection bill debates, said a new data protection bill is needed, but perhaps not this one. I think perhaps is probably a slightly kind word to use, given what DipDib will do, which in short is make pretty much everything worse. What does the bill actually do? Well, this is sort of how it's organised. So there are 6 main parts. Part 6 we don't need to worry about, that's more the technical side of it. Part 1 is fundamentally about changing the data protection regime. So as Michael said, amending bits of GDPR and the Data Protection Act. That includes changing definitions around certain things, including personally identifiable personal data, around scientific research, around democratic engagement. We'll come back to that in a second. It changes requirements on data protection impact assessments, data protection officers, and so on. It also makes changes to legitimate interests where people can use your data for things, including introducing recognised legitimate interests, which actually sweep away quite a lot of the safeguards and the need to balance with the public interest. There's quite a lot going on in that part. Part 2 is about setting a framework for digital identity verification. Part 3 focuses on smart data initiatives, things like building on open banking, which allows consumers in particular sectors to share their data with intermediary services to try and make the consumer experience better. It's noteworthy that Part 2 and Part 3 haven't had so much attention. There are fewer amendments down at the moment to make changes to those parts of the bill. I think those are the bits that we would expect to see go through and actually seem to have attracted a fair bit of support when it comes to smart data, or are seen as setting the framework for future regimes when it comes to Part 2. Part 4 covers other bits of digital information, so international transfers are in there. Cookies, again, as Michael said, I think there's a lot more agreement around that. There's also some stuff in there which is a bit more controversial around police and security services powers. Birth and death registration pops up in that one, which is slightly random. Part 5, with Part 1, replaces the Information Commissioner's Office with an Information Commission. At the moment, the ICO is a corporation sole. Technically, all of the powers are vested in the individual. This changes that to sort of turn it into a slightly different sort of body. That's less controversial. There are, and again, Michael touched on this, there are other measures in there about the independence of the ICO which have proved more controversial. So that's what it's setting out to do. The government says that that will bring a Brexit benefit. In the same breath, It says it's going to reduce burdens on business and it will maintain EU adequacy. So the main selling point of the bill is that we can diverge from the EU regime, but also we're going to be able to maintain data adequacy and everything will be fine. They say that it clarifies some of the rules, because obviously things have moved on even since GDPR was enacted. It does more to support international trade, enables innovation, and will increase public confidence in things like automated decision making. They have not described it as world leading, which the government is fond of using when it comes to many things. But one peer in the House of Lords expressed their concern that the government haven't called it world leading, because how bad must it be? Some of the things that we're connected by data are concerned about is that it's trading off citizen data rights for minimal and unproven economic benefits. We looked at the economic impact assessment that the government had done. It reckons that it will save businesses on average £80 a year. £60 of that apparently comes from changing the subject access request regime. I think we're fair to say we're sceptical of that, not least because a lot of small and medium-sized enterprises are already exempted from some of those more burdensome requirements. So again, lessening protections, lessening rights, and it's not obvious that it will bring economic benefits, especially if there is a loss to adequacy. It undermines existing safeguards, parliamentary sovereignty and democratic data governance. There's a lot of leeway given to the Secretary of State and the Executive in there. And in fact, it misses that opportunity to build public confidence. I think we'd all like to see greater innovation. You're only going to achieve that if you build public confidence. And we have a lot of examples of what happens when you don't do that. Since the bill came in, we have, of course, Horizon has come to the forefront of public consciousness, which I think is a salutary tale in terms of what happens when we put blind faith in data-driven and technologically assisted decision-making. I think it joins things like robo-debt in Australia, the Dutch childcare benefits scandal, and also things like the algorithm and exam sort of crisis here in the UK as well. Things that can really damage public confidence, and the bill misses the opportunity to rebuild that. I mentioned that we're working with a lot of other civil society organisations, everyone from which the consumer organisation to bodies like the Open Rights Group and Big Brother Watch, who think about civil liberties, to the Trade Union Congress, lots of different groups. And these are some of the other concerns that have come through them, and we've also seen in Parliament. The bill focuses on business and the economy. It was co-designed for and with and by industry, according to the King's speech, rather than thinking about citizens or communities, the more social aspect. A lot of people are worried about the threat to EU adequacy. This was a really strong theme when the bill was first debated in the Commons. There are real concerns about automated decision-making, and it doesn't really touch on AI as much as it might. That reduction in rights reporting and redress and transparency in general. People are concerned the definition of scientific research would bring in a lot of sort of dodgy commercial research, quote unquote. There are a lot of safeguards go when it comes to legitimate interests. The independence of the Information Commissioner's Office are threatened, and there's a lot of power given to the Secretary of State. The government's approach to this being a fast-moving and therefore quite difficult to regulate world seems to be to put lots of Secretary of State powers in there. They can fill the detail in afterwards. There's less parliamentary scrutiny, and we don't think that that's okay, really. So those are some of the concerns. Here are a lot more. Quite a few of these come from the House of Lords as well when they got to debate the bill recently. So the bill proposes to abolish the post of Biometrics and Surveillance Camera Commissioner. The outgoing commissioner warns that that leaves a gap around biometrics data, and our friends at the Ada Lovelace Institute, I think, would like to see more in the bill on biometrics in general. Cookie consent, again, generally quite a lot of consensus that that's a sensible move. There are a few discussions about the practicalities. Children's data rights and coroner access to data. Some of those issues are a hangover from the Online Safety Bill, now Act, and the sense that the government had reneged on a promise made to families on that one. There are expanded powers for security services. Obviously, there isn't really much directly around AI, and there's a sort of lack of general policy coherence. The government's AI white paper, which was published last year, and obviously the world has changed quite a lot since they published that, talks about the importance of transparency, accountability and explainability. The bill seems to go in the opposite direction. The Online Safety Act seemed to be clamping down on big tech. The Data Protection Bill seems to give them much more permission to use people's data in interesting ways. Other things that have come up, the length and complexity of the bill, there's so much in there now. It's a bit of a Christmas tree bill, as it's known. Lots of people hanging different baubles on the bill, which makes it quite difficult to scrutinise, especially given the technical complexity. And the lack of scrutiny. That relates particularly to a couple of things that the government added at the last moment in the House of Commons, and we're now dependent on the House of Lords to have to really drill into these issues. So one is around giving powers to the Department of Work and Pensions to be able to access the bank account data of benefit recipients. That includes pensions and universal credit and everything else. Huge amount of controversy that that's been added so late, but also that it seems to be giving sweeping powers without any scrutiny at the last moment. This was not discussed anywhere in the bill process until it suddenly appeared. The Information Commissioner has said that they have not been convinced that those measures are proportionate. So there is real concern around that. And then we've got the democratic engagement element. So this is about political parties' use of data. There are a few different things in there, again, giving the Secretary of State powers to do things there, being able to switch off direct marketing rules before an election. Switch off is not my phrase. It was former Minister John Whittingdale who said that on behalf of the government. So there could be some quite bad practice there. It's striking that the Advertising Association are among those bodies expressing concern around this part of the bill because they think it could encourage further bad behaviour. It's interesting as well that the other political parties, the opposition parties, are opposed to those clauses. So those things that came in quite late, quite controversial and could be quite wide-ranging. So what do we think should be done? Well, we don't think the bill should pass in its present form, and I think that's quite a common view across civil society. We are focusing on particular amendment areas. We would like to see the automated decision-making provisions apply to decision subjects, not just data subjects. We would like, rather than lessening the requirements around data protection impact assessments, we'd actually like to see those extended to considering those collective risks on groups and society as well as individuals. One of the things that is also lessened by the bill are requirements around consultation. So, for instance, if you're a worker and your workplace decides to implement some new technological solutions, your right to consultation is diminished by the bill. We'd actually like to see more requirements around impacted communities being consulted. We'd like to see collective redress mechanisms for collective harms. EU GDPR has Article 82, which does allow collective representation by groups. That's not something that's been commenced in the UK. We would like to see that. And we'd also like to see greater transparency around the use of AI, particularly in the public sector. The Public Law Project have been doing a lot of work on this. We'd like to see mandatory transparency reporting around the use of algorithms. Amendments have gone down to this effect on all of those points, a lot of them from Lord Tim Clement-Jones, Liberal Democrat lead on Lords on this. There are some other areas that we're particularly concerned about. So again, I mentioned recognise legitimate interests earlier, which sweep away various safeguards. We'd like to see that concept removed. Subject access requests, we would like to sort of go back to what we've got at the moment rather than this new definition of vexatious or excessive. And we would like to see those DWP powers removed because we think they could be really damaging to public trust in the new regime. So in short, to go back to what Jim Knight said, this is not the data protection bill that we need. It's the one that we're currently stuck with. It's the one that we will hopefully see amended in some ways. And I think there is also real worry that this bill will get passed and actually we'll have to pass another one at some point in the near future, having gone through the rigmarole over the last few years already. So we don't want to see it pass in its current form. We know that reform is needed, but it's not along the lines currently being suggested. So thank you very much.
Okay, thank you very much, Gavin. I think that was a pretty comprehensive overview of some of the problems that different people have raised with the bill and some of the things that might be useful in changing it to improve things. Our next speaker is Vivienne Artz he is a data strategy and privacy policy advisor to the Centre for Information Policy Leadership. Vivienne, if you want to come up, please. Again, 15 minutes on good things, maybe some bad things, who knows, about the DPDI bill. Thank you.
Thank you very much, and hello everybody. So just to preface, the comments I'm making today are my own comments. I am an external advisor to the Centre for Information Policy Leadership, but I also do a number of other things, and I know I've seen some of you in the room here before, because I'm also the founder of the Picasso Privacy Awards, where we actually look to showcase what good looks like in terms of data protection and practice, both by individuals, by groups, and by organizations. So what good looks like is actually, I think, what we're all hoping to achieve. So I thought I'd start today with our remit, which is, where is the UK data protection today? Because I think it's important to see it within the broader context. And so I had a look at the ICO website, and oh my goodness, it is more than the DPDI bill that I know is a focus for today. But of course, we've got the Data Protection Act, the Freedom of Information Act, we've got PECR, we've got the UK GDPR, and a whole raft of other pieces of legislation, all of which touch on data, particularly the NIS regulations, and of course the Online Safety Act as well. And so I think we need to be thinking about this much more holistically. And I think that's a theme that's probably has already emerged and will continue to emerge, is that data protection is one piece of it, but it actually sits within a broader set of legislation concepts and the economy. We talked a little bit already about the UK digital strategy, but I thought I'd just remind ourselves about what is the UK data or digital strategy as set out by this government. So they've set out 6 different priorities. In terms of that strategy, they've said that there needs to be a proper digital foundation and infrastructure. And that goes beyond having access to 3G or 5G, as the case may be. But it's also about having a light touch, pro-growth regulatory regime, which will protect while encouraging investment and innovation. And so that's very much one of the drivers for the DPDI bill and the strategy more generally. They're focused on supporting ideas and intellectual property generation, whether that's through AI, semiconductors, digital twins, automated systems, and quantum computing. So they very much have an eye on the future and where is technology and data moving toward. There's a focus on skills and talent, which of course is hugely important as well. How do we actually achieve what our ambitions are if we're not educating from the school system and also re-educating within our environment? Because this isn't a shift that's taking place over a generation. It's a shift that's taking place in a much more compressed space of time. And actually, it's super important that we start reskilling our existing workforce as soon as possible. There's a focus on encouraging finance and investment to support that innovation and that data economy within the UK. A focus also on levelling up to make sure that this doesn't sit within specific pockets geographically within the UK, but all of the UK benefits from that. And it's also about enhancing the UK's place in the world. And the UK has taken a lot of steps toward that. It's not to be isolationist, not to sit by itself, but to join lots of groupings and international fora. So they're part of the Global Partnership on AI, the UN Internet Governance Forum. They're fully engaged within the OECD and the International Telecommunications Union as well. So the approach is supported by, it's basically supported by the digital strategy is supported by a pro-innovation approach to regulation. And I think a lot of this stems from the perspective that we actually need the opportunity to innovate in order to understand the risks and to address them. Essentially, you won't know what those risks are unless you actually start playing in the sandbox, as the case may be. So different jurisdictions may take slightly different approaches to this, one of which is actually we're just not going to do a whole bunch of stuff. And other jurisdictions take different approaches, which is, well, we're not going to know unless we try. We can do that, hopefully with appropriate safeguards in place. But if we don't try, we won't actually know what those potential risks are. There's also the other piece of it, of course, which is those missed opportunities. If we don't try, we won't actually achieve those missed opportunities and those opportunities to make a difference in terms of data. So what is working? Well, I think we've heard already that we think that the UK ICO might have its challenges, but is generally a respected regulator with practical and timely guidance. Internationally, they're respected. I know we always like to have a go at our own regulators internally. We've always got a lot to say about them, whether it's the ICO, the FCA, the CMA, etc. But internationally, our regulators are regarded fairly highly compared to others because they are responsive. They do make an effort to be well informed. They do engage in consultation, and they do produce practical as opposed to legalistic advice, practical advice that is accessible by SMEs, that is accessible by individuals, as well as by business and by lawyers. And that is actually super important. I think we deserve a shout out as well because the UK organised the first global AI safety summit last year. Who's going to take the lead on this? The UK did, and they brought together everybody, including China, into the room. So the UK is third in the world in terms of AI innovation, and actually bringing the world together to be the convener, not to tell, but to share ideas and to listen, I think was a super important move. The UK, of course, has issued its AI strategy white paper, and by the end of April, they're expecting regulators to present their strategic approach to AI. So it's not a regulation. The EU has an AI Act. The UK has decided not to proceed with an AI Act at this time, but instead to enhance the capabilities of the regulators, to encourage them to conduct the research and to produce the tools to understand what does AI mean, the use of data within their regulatory silos, so that they can then liaise and actually work out what it means more generally, and we can actually discover what those gaps are. So let's have a think about it before we actually leap to regulate. The UK participated and was a significant driver in terms of the OECD government access to data principles, which were published last year as well. So they are principles, but I think the big piece about government access to data is that it's just so very important to understand what data does government access, why do they access it, and what are the safeguards that they have in place. And the OECD initiative brought governments together to talk about this for the first time. It's always been regarded as a national interest issue. We don't want to share, we don't want to talk about it, everyone does it their own way. And actually this is an excellent step in the right direction. It isn't a legally binding commitment, but certainly those who signed up to it, and it was a large group of companies, agreed on principles around transparency and responsibility toward government access to data, which I think is a first important step in terms of building trust with the broader population around how their data is going to be used. I think a lot more work to be done there, but that first step was an important one. We're one of the first countries to implement the Online Safety Act, which it's obviously being amended now already. It provides a framework. It's not the be-all, end-all. I would suggest it's very much in its starting phase, but it is a very good start. We also have the ICO's Children's Code, or the Age-Appropriate Design Code, which implements 15 standards to allow children to engage more safely on the internet. Again, leading in relation to children, an area of vulnerability that not many jurisdictions have been focused on, and I think one which is super important. We also have the Digital Markets Unit, which has been created within the CMA to promote competition and to address unfair behavior of the largest digital tech firms, which we all know is a hugely important issue. We also have the DRCF, which has been a leading light, and other jurisdictions we are seeing taking this up, where we have regulators coming together to talk about the overlap in relation to digital and the importance of sharing understandings and achieving regulatory coherence, which I think is incredibly helpful. And then, of course, we have the DPDI bill as well. So let's have a look at the DPDI bill. These are the main sort of themes, in my view, that sort of pop out in terms of the DPDI bill. The government did consult, and it has been on quite an interesting journey. I suppose through the various industry bodies that I've been engaged in, we provided a lot of feedback to the DPDI bill. I think one of the biggest challenges with the DPDI bill is it's almost impossible to navigate. And one of the things that we've asked for is absolutely a consolidated draft if and when it actually passes, so that it can be read by a normal human being and hopefully be slightly understandable. But at the moment, it's an amendment, and which makes it very, very difficult to navigate. But its focus has been on recognising perhaps the burden of the one-size-fits-all approach of the UK GDPR on SMEs and others, and also to address some of the practical challenges and genuine bottlenecks in terms of compliance with existing data protection law. And I would say, having been a chief privacy officer, having worked in privacy for over 25 years, having dealt with subject access requests, having tried to apply and implement data protection legislation effectively and efficiently within a global organization, I fully understand what those practical challenges are. And you can't always implement it exactly. You cannot always get it right. And one of the challenges I think that we have is that we follow too frequently a tick box approach. Do I have a policy? Yes. Is it of good quality? I really don't care. It goes on. International transfers, as long as I've got the contracts in place, that's all I'm really interested in, because that ticks the box. And I think what the DPDI bill tried to do, I don't know whether it's achieved that effectively, is to shift that responsibility away from the tick box approach and actually say, you know what, you're accountable as an organization to demonstrate responsible data practices. And so some of the things that I think are actually quite useful, I know there was a complete freak out about data protection officers being removed and then being replaced with a senior responsible individual, but actually I think it's a great thing, because a senior responsible individual has to be a senior person. Where does data protection generally get pushed down to? It gets pushed down. It is not a board level issue. Remember when the GDPR first came out, the DPO was going to report to the CEO? No, this is what's seen as a niche or a siloed topic within most organizations, particularly when you're only talking about personal data. And having come from a regulated sector, that senior responsible individual, although they may not be an expert in data protection, they are ultimately accountable within that organization. And as a result, that generates a whole different set of behaviors. I always think more effective than fines is one of the UK ICO's powers, which was, I remember they effectuated that against Barclays many, many years ago. I knew the CPO at Barclays at the time. And they made the CEO sign a letter of undertaking with regard to their poor data protection practices. Well, when the CEO had to sign a letter of undertaking saying, I understand that our data protection practices were dreadful. We breached the legislation, and I undertake on behalf of my organization to do a better job going forward. My goodness, the budget, the focus, the resources, the transformation that took place as a result was far better than any fine, far better and effective than any fine. And so my sense is that that senior responsible individual, they've got to sign off on this highly volatile, increasingly important, this horizontal issue. They're not going to do so blindly. They're going to do so wanting to know that actually compliance is a reality within their organization. The ROPA is going to be replaced by a record of high-risk processing. Actually, I think that makes sense. It really does make sense that what we're focusing on is a risk-based approach, and rather than documenting everything that doesn't actually need to be documented, that we're focusing on those areas that are important, and that's where we can focus our resources accordingly. The same thing with the approach to the DPI, which is going to be replaced with a high-risk processing assessment. Again, that makes a lot of sense. With regard to legitimate interests, I know that has attracted some level of criticism, but I certainly, through my industry bodies and through my organizations, did lobby for having recognized legitimate interests. If I'm processing data in accordance with a legal requirement for the purposes of a legal requirement, why am I doing a legitimate interests assessment to say, oh yes, I do have a legitimate interest in processing this data because I have a legal obligation to do so? It just seems to be a waste of time and actually an unproductive use of resources. Recognizing that certain things are actually legitimate interests allows you to move on to the next step straight away, which is how am I addressing those risks? How am I addressing my compliance obligations, as the case may be? On automatic decision-making, very complex and volatile area. I think there's still quite a bit of work to do in that space, but I think the profiling alone is no longer automatic decision-making, is interesting. The approach is, looking at safeguards rather than prohibiting the actual processing of the data, I think is helpful. It'll be interesting to see how that moves through the House of Lords. On the research, actually, from a commercial perspective, from an organizational perspective where we've always focused on compliant approaches to data protection, it's incredibly helpful. That piece is actually incredibly helpful. As with everything, there's use and then there's misuse. And I think what we should be targeting is the misuse of these provisions, but also allowing legitimate business and legitimate practices an opportunity to flourish. There's many more other elements to this, but for me, those I think were the actual priorities. It isn't a rewrite. In a sense, it would be quite nice if it was a rewrite, in my view, because the piecemeal approach makes it very difficult to understand. And I'll speak a little bit later about some of the areas where I think the future should lie for us, is that a lot of the concepts within the existing structure are very difficult to apply to our digital economy as it is evolving now. And we're stuck with terminology and constructs that don't really match, particularly those concepts around controllers and processors. The need to balance rights. We have rights and obligations in different areas. Data protection doesn't trump all, and it shouldn't trump all. It is hugely important, but there is a balance to be achieved as well. So let's move on to some of the new additions, because those were obviously the original ones. We've spoken about some of these already. So in relation to SARS, that organizations will be required to conduct reasonable and proportionate searches only. I recognize that some of this may be subject to misuse, but having been on the receiving end of very vexatious and unreasonable requests for subject access requests, it actually does make a lot of sense. When I think about the level of resources and cost that gets invested in dealing with some DSARs that are just intended to penalize an organization, that aren't actually intended to provide an opportunity for an individual to see what data that it is being processed, that isn't there to actually recognize their rights. I think it does absolutely need a common sense approach toward it as well. I mean, I've been in the room where we've spent weeks and we have crates of documents, and it was the only reason that we were going to have to do all of that is because somebody had a grudge, or they were trying to preempt the disclosure process in relation to litigation. So there has been a considerable amount of misuse of the data subject access request. We have to keep the data subject access request. It's absolutely essential for transparency and accountability within organizations, but having the ability to take a more common sense approach to it, I think, is a good thing. Interestingly, the provision around the data preservation process to retain vital information in relation to inquests, in relation to social media and so on and so forth, again, very targeted and specific. It seems to make sense. We'll see where that goes. The extension of biometric data use for national security will effectively align the UK with Interpol's retention rules. Seems to make sense. The DWP powers to check bank accounts of claimants, I can see how that is quite a volatile topic. But what's interesting is that benefit fraud costs the UK about 8.3 billion a year. And when you look at all crime in the UK, 40% all crime in the UK is fraud. If the right can be used in a responsible way, it's actually to the benefit of everyone. So I can see where this is coming from. And that's part of why, I think we need to be thinking about this much more holistically. How do we enable this with also imposing or allowing the appropriate safeguards to apply as well? And then, of course, the amendments to process for approval of strategy and codes produced by the Commissioner. What we're seeing, of course, is a much bigger role for the Secretary of State in relation to data protection and what the Commissioner does. The focus, I think, is to make sure that it aligns with other regulators and aligns with the ambitions for the digital economy within the UK. So what improvements should be made? Well, I'm a great advocate of taking a much more holistic approach to data. We've had a very firm focus on personal data for a long time, and rightly so, because it has been neglected for many years. But I think we also need to be thinking about data more holistically and thinking about it in terms of society and both personal and non-personal data. Particularly in the context of AI, we're seeing that is hugely important. I think that we need to be thinking in a much more technology neutral way. because if we think of things like blockchain, for example, it is a technology and a way of using data that imposes real challenges on the constructs and the terminology that we're using for data protection today. For example, in a distributed network, how do you allocate the roles of controller and processor? Actually, it's incredibly difficult to do so, if not impossible. So how do we apply our focus on privacy and how we understand it and those roles and responsibilities to new technologies and environments? In the blockchain world, everything is a copy. How do we apply those data minimization principles? In the blockchain world, transparency is everything. It provides for absolute auditability, which is fantastic, but it also creates real challenges in terms of how do we keep things confidential, how do we keep things secure, how do we keep things private. We can all go our own way in a national approach, but for me, I think that mutual recognition is absolutely the way forward. We need to be thinking about how can the UK fit in with the evolving legislative environment across the whole world. Different jurisdictions are taking different approaches because they have different drivers. The US is very consumer protection focused. If you go to China, they're very much focused on the national interest. If you go to the EU, they're very much focused on fundamental human rights. How do we achieve mutual recognition of similar standards in a way that will enable the data to transfer, because that's actually what is happening throughout. Technical standards versus laws. I think if we focus on a national-only approach, we are going to become increasingly unstuck. And I'm a great supporter of increasing agreement on technical standards, particularly around the security of data, something that can transcend jurisdictions, that then becomes jurisdictional neutral and can provide a consistent standard that will enable trust in data flows going forward. I think it's important to be outcome focused in terms of our approach. So what are we actually seeking to achieve as opposed to the way of actually doing that? I think digital identity and verification are increasingly important. So I think the two bits of the DPDI, smart data and digital identity and verification, haven't received the focus that they should have. I think there's a huge amount to unpack there. There's a huge amount of opportunity, but we also need to move forward a little bit more quickly, because in this digital environment, we're increasingly seeing misuse of data, fakes of data, or digital fakes of people, and so on and so forth. That ability to identify and differentiate between fact and fiction, to be able to validate who you are as opposed to those who are impersonating you, is becoming increasingly important. And I think that actually we need to be building out on the DRCF, that coherence and cooperation between regulators, not just at the local level, but at the international level, is the way in which we have to do that. We can learn from each other, and we can also help influence a consistency in terms of standards towards data, because this isn't just a national issue. Data is increasingly international. The platforms, the services, the economy that it relies on is increasingly international. And I think we need to be thinking much more in a big picture way. Thank you very much.